So today we are here with Michael. We have a very interesting story here, and we're going to expose something that I believe is actually happening across the nation. Correct? Michael, you want to give a quick introduction as to who you are, where you come from?
I'm Michael Moore. I grew up in La Mesa. Married Christine. We bought this house in 2001. We were married right here where we're sitting, basically. We have 3 children. Actually, both of them are special needs because Michelle has a hearing disability and Vivian has cerebral palsy and seizure issues.
What'd you do for a living?
I drill water wells. I have 2 trucks sitting here in front of the house. One was my granddad's and one was my dad's. So been doing it a day or two.
Currently, where are we right now? What city? What?
We're in Midland, Texas, Midland County.
But we're us. We're saying we're in Greenwood. Is this Greenwood?
Yeah, this is Greenwood.
And Greenwood's just a community, right? Basically.
Yeah.
Because
Well, it used to be just a small community, but not anymore.
Okay. So what brings me here today is a situation here with your house. So if you can give a beginning start point of all this, what's happening, can you go ahead and tell me, from your viewpoint, what's happening here? Because this is pretty interesting to say the least.
Well, in December of 2015, December the 15th, they foreclosed on our home. I tried to pay the home off. They refused the money. I have a documentation from a mortgage company where we were guaranteed the amount of money in excess to pay the home off. Basically, the house and the mortgage is 1 acre. And the house actually goes over onto our property because we own the adjoining 79 acres, which according to Texas law, you cannot foreclose unless you have a clear title. So they didn't have a clear title because part of the house sits on our property. During the
And was sorry to cut you off, but why does that your house sit on the property? I mean, you
when
showed us a room.
we did an addition. We informed them. Was up to them to perfect their lien, to encumber that part of the house. They didn't do it. Not our fault. Then during the foreclosure proceedings, one of the trustees forged Christine's name on a quitclaim deed.
And you have the proof about that?
Yep. Yep. They forged her name on a quitclaim deed, which is fraud. Actually, there's more than her involved. There's several attorneys, banks. So now you're talking about organized crime.
Tell me about it in this area. Okay, so continue on with your story there.
We tried to pay them off. They wouldn't take the money. That's against the law. They have to take the money.
You have that documented that you tried?
Yeah. I have the paperwork from the other mortgage company.
And what did they tell you? Like, what was the
We
process?
don't want your money. We want your house.
They told you that?
Yeah. In front of the justice of the peace.
In Midland?
Yep.
Okay, go ahead.
Article 1, Section 19 of the Constitution of Texas states in due course of law, no citizen of this state shall be deprived of life, liberty, property, privilege, or immunities, or in any manner disenfranchised except by the due course of the law of the land. Okay, when this first happened, I called 75 attorneys. The minute I told them we were going against Fannie Mae, click. Nobody take my case. Got a hold to one guy. He was a foreclosure advocate. He told me to file bankruptcy. I didn't have to go through with it. They'd dismiss it after 6 months. Told me I could do it 3 times.
Well, what was the thought process to do that 3 times? What's the reasoning?
To delay having to leave the home, because once we give up possession, because in Texas, or any state, possession is 9/10 of the law. Trying to get them to accept our money.
Oh, so this is an attempt for them to accept the money. You wanted to delay their proceedings, and someone gave you some advice, a lawyer gave you some advice to do so, correct? File
Yes.
bankruptcy. All right, go ahead.
File the bankruptcies. Well, we did that for 18 months. Then July the 7th of 2015, we had already cleared out the house, but the sheriff came with his gun on, other people to make sure we had left the property. Well, when they did this, and I didn't find this out till later, because we had met some people that were into common law. Well, when we met them, he helped me draft the affidavit of title of possession, trespass tri-title, to file to take possession of the home back. And they can't file trespass charges on us because the broker that represented them gave us the code to the lockbox to come back into the house.
Why did he do that?
I have no clue. I told him, nobody checks the house. What if there's a water leak? We were living right here in 2 FEMA trailers in a storage building on the property.
For how long?
From 19 to 3 years, 3.5 in the time we had to move out of that rental or leased house.
So you're saying they came and got you by gunpoint to get out of your home?
Yep.
And you had to live on the property on your 79 acres or part of it in FEMA trailers. So how did you feel just watching your house just sit there?
Was not a good feeling. Was not a good feeling.
Lived in a hotel for 3 years.
Yeah, first time when we first had to move out, we had to live in a motel for 6 months until I found a home we could lease for $6,000 a month. Now I could afford that lease. What makes you think I couldn't afford it? What was it, $1,200 something house payment? We lived there for nearly a year and a half, and then the constable knocked on the door one day, and those owners had been foreclosed on. So we had to move out, went back to a hotel for about 6 months. Yeah, 6 months. And then by then I had come up with the 2 FEMA trailers that 5 of us were living in. My wife, 2 special needs children, and another daughter.
And you got 79, 80 acres here, correct?
79 acres outside of the house and 1 acre.
Okay, continue.
Property set vacant. We tried a couple times to buy it back from Fannie Mae, and they didn't own it. The broker finally sent me an email, and he didn't have on there who owned it because they denied owning the property. And they wanted $580,000 and something dollars, and we owed $260 when they foreclosed on it illegally. And one thing everybody overlooks, when you have a special needs child under the age of 16, by federal law, they're supposed to have another roof to put over her head before they take her out of that home.
They didn't do that?
Nope, put her right out there in the street.
Penal code 22.
It's Penal Code 22.04. And then we got into the common law. We filed the affidavit, moved back in, and just waiting to see what they did. We filed a criminal and civil counter complaint against them. This has been totally ignored from the minute we filed it. We filed it in county court, JP court, or county clerk, district clerk, and the JP clerk. All 3 of them had that. Let me show you kind of what we're looking at, the depth of it. It's 52 pages thick, our criminal and civil complaint. And we moved back in, and then in March of last year, roughly, their broker called and asked us what it would take for us to move out of the home. Which tells me if they had any kind of legal right, why would they have offered us money to move out? So I said, okay, well, we already filed the affidavit of title possession and trespass tri-title, see you in court. And about a month later in April, no, that was probably in May, 1st of May, I get a call from an attorney from Aldridge and Pike. San Diego is where that number was, but their main office is in Atlanta, Georgia. telling me that they represent the owner of the property. I'm like, okay, who do you say owned the property? Fannie Mae. I said, isn't that odd? They were denied owning this property for 5.5 years. Click, she hung up on me. And a little over a month later, we get served with eviction papers from the same attorney with a different mortgage company, Freedom Mortgage Corporation. So we had to answer the JP. I mean, they served eviction papers on us. We have to go to JP court. We gave him an answer to the suit with 9 questions on it. Prove title. I mean, prove you even have consideration. Because they used the original eviction papers for this one from 2015, with the exception of one document. And it's a security deed with Freedom Mortgage on it that's dated January of 2017. Not any paperwork up until this point. And it's out of Indiana. So I researched it, and it's dated January of 17. So I researched it, and notaries in Indiana expire every 6 years. Well, this security deed, the notary stamp, expires in September of 24. So I brought that to their attention.
And what's the reasoning behind that? What does this actually mean?
Well, they put a fraudulent security deed into the eviction papers. Oh, we're just getting started, bud.
Okay, continue.
So we filed an answer to the suit with the JP, 9 questions. He's supposed to answer everything in our suit, in our trial. They hired an attorney from San Angelo, this Aldridge Pete, the night before we go to JP court. He didn't even know nothing about the case. We go into JP court. I'm like, we filed our lawsuit with you, our counter complaint, and there's no clear title. Well, according to the laws, the Constitution, the minute I brought up no clear title, our case was to be moved to district court because that's the only one that has jurisdiction over title. He ruled on it. I had to pay court costs and file an appeal on his ruling. Never addressed anything in our answer. We weren't in JP court 5 minutes. And so then we have to appeal to county court. So I paid the $1,000 bond, paid the court fees. Now I'm waiting on county court to send us a court date. When are we having court? Nothing. Didn't need anything. This is July the 2nd when we had JP court. Nothing from the county court. Except I got an email on Thursday, August the 16th, from the court clerk.
August of last year.
Yeah, 24.
Okay.
From the court clerk, final judgment of possession. They had court on August the 15th, and we failed to appear.
But you didn't know about that?
We never got served a court date.
Is that illegal in itself there?
Nope. So I drove home from Stephenville. Friday morning, Christine and I go to the court clerk. I'm like, you never served us a court date. And she says, oh, let me look. Oh, you're right, we didn't send you anything. So she took it into the other judge, county court at law judge. He vacated that judgment because we weren't served.
What does that mean, vacated the judgment?
Well, he just did away with the judgment. It vacated what the other judge had ruled. Okay, they told us right there in the office, Christine's my witness, we'll set you another court date and we'll let you know.
This was where at?
County court at law, clerk. In Midland.
Okay.
Midland County Court at Law 2, county clerk. We'll let you know. We'll set another date and let you know. Okay. Rock along here, we get nothing from the court. We get a letter from the opposing counsel that we're having court on September the 10th. So I called the court and I said, we can't do the 10th. We've been waiting 6 months to get Vivian into Cook's Children. Okay, well, what about the 19th? I said, we can do the 19th. She said, okay, well, let me check with the opposing counsel and I'll let you know. I called him on the 10th when we were leaving because I didn't want him to pull the same crap on me again. And she said, oh, I talked to them the other day. We're good on the 19th. I said, well, I appreciate the notice. So We filed a motion in Justice of Peace Court and a motion in County Court to move the case to District Court for jurisdiction. Okay? Sorry. Nothing. They even filed it in District Court to move it to District Court. Nobody addressed it. We didn't get a pretrial hearing or anything at County Court to address jurisdiction or anything, any motions we might have wanted to bring up. So we get a court date of September 19th. And we go into County Court at Law 2, and we're representing ourselves. And he asked if we wanted testimony. I said, yeah, I'd like to give you testimony. So I started my testimony. I informed him. I said, look, we have a counter complaint, civil and criminal, filed on the same property. That needs to be adjudicated before this can even be addressed. Also, they sold the house for $84,000 more than what we owed on it. We ain't seen a penny of that. I said, they put special needs kids in the street. By federal law, you can't do that. I said, the other thing is there's no clear title on the property. The minute I told either one of them it was a title dispute, they were to shut the case down and move it to District Court. Nope. My common law guy, because you have counsel, you can have counsel. Don't say you have to have an attorney. It says you can have counsel. Okay? And he's a constitutional scholar. He tried to argue with the judge about the constitutional, and we have a criminal and civil counter complaint. The judge's reply, and this is on the transcript. No, excuse me. It was in court with 3 witnesses. They removed it from the transcript. He informed Charles that we don't have time for that today. I've got other cases to hear.
Who was the judge?
Marvin Moore. And they didn't put that in the transcript, though. They took that out when I got the transcript. That was taken out. Every time Charles tried to question him, he just shut him down. Am I wrong?
Not at all.
And then he says, well, I'm going to rule for the plaintiff, and you're going to have to post a bond. And he asked the attorney, well, what kind of bond do you want him to post? I thought that was up to the judge. So he hit me with a $4,000 bond to stay in the house. And then after he said, well, you know you have other avenues. I said, yes, sir, I know. Because as soon as you sign that judgment, I'm filing notice of appeal. He looks at me and goes, and this is not in the transcript either. Well, I hope you have better representation next time. And I wanted to I don't need better representation. I just need somebody to follow the law.
Ain't that right?
I mean, that's the bottom line. Okay, so I filed a notice. I paid the bond, and then I filed a notice of form of nonconvenience, which is I want a new trial in a new court. And anytime you file a motion for a new trial, that gives you 90 days to file your appeal instead of 30. Okay, so file that. Also filed a motion to disqualify the judge because he had no jurisdiction.
What do you mean he had no jurisdiction?
He has no jurisdiction over title. He couldn't even rule on the case. He's supposed to be disqualified. And when you file a motion to disqualify the judge, the law states, their court rules, their law rules, he has 3 days from the date he gets that motion to either contact the clerk that he's recusing himself, or he's sending it to the regional presiding judge. No questions asked. That's what the law says. He did none of it. Totally ignored it. I filed a motion to dismiss for lack of jurisdiction. I filed a motion for discovery. Make them prove they even have any consideration on this. They haven't even proved consideration that they have any right to anything. Ignored everything. Just wrote court reviewed on the bottom of them. Never addressed one of my motions.
And that was back in, you said, August or September?
That was probably, at day 56, which was in November, like the week before, The week of Thanksgiving, wasn't it? I get a call from the deputy. He's got a forcible detainer to put us out of our home again at gunpoint. And here's the funny part to that one. We had no contract on this because we took peaceful possession of an abandoned property. The whole time it sat here, we did the yard. We cleaned the whole place up. They never did anything. Well, if there's no contract, you can't issue a forcible detainer. It's illegal. It's against the law. You have to have a contract to enforce a forcible detainer. Okay? Well, at day 56, he sent him out. So I went ahead and filed my notice of appeal. Well, then the appeals court wanted to know why I was late filing my appeal. So I wrote him up a writ of mandamus. This case should be dismissed. He has no jurisdiction. Shouldn't even be in an appeals court. It's a void judgment from the beginning. Well, they sent me back that they had denied my appeal. So I sent them back another letter saying, okay, review my appeal. Asking for review. And in the meantime, I filed a motion to quash the case because he had no jurisdiction, along with an affidavit, signed affidavit. And I had him served while he was sitting on the bench. He got served.
More?
And nothing. Court reviewed and stuck it in the case file. They don't like pro se litigants.
What does that mean?
You're representing yourself. They do not like pro se litigants. They run over you if you let them.
Why do you think that? Because
they think that you don't know the law, and they'll just do what they want to. And I've already been told by several people inside the legals of Midland County that he hates pro se litigants. He will just run over them. But he's in for a very rude awakening. I'm filing a new lawsuit. Let me go back and finish this.
go ahead.
After that, we kind of rocked along, waiting on them to review it. And then they send it back that, they sent it back, and I sent back for the review. This was like in December. And the last of December. I rock along there, and on February the 7th, we were going to Oklahoma to get Christine the Jesus shot for rheumatoid arthritis that started once she had to deal with all the stress of this. And Christy met the constable down here on the road. And she talked to him, and then I called him. I said, look, I'm traveling. I'll be home Monday. I'll come by. So Monday I went down to the constable on my birthday, as a matter of fact. What a birthday present. Explained the situation to him. I mean, look, I filed an appeal. I took the motion to quash. I took the motion to dismiss. I took the motion the notice of void judgment and listed why it's a void judgment with the affidavit and a copy of our counter criminal complaint and civil complaint. And he looks at it and goes, well, I thought something was wrong. This just didn't add up. And he's new. He just started in January. I said, it's a void judgment. And he read the judgment. He goes, based on this, it's a void judgment. I just want to make sure I'm following the law.
Well, thank God he had that right attitude, because
Yeah.
he could have been a tyrant and wanted to just step all over you.
Well, here's the kicker. That same attorney that did the fraud on who he's representing, told us he had one mortgage company owned it. Then he comes back and files a suit on with another company. The reason the constable had called, because that attorney sent a writ of possession to the constable. That's not a court order. That's circumventing the court. I got a lawsuit fixing file on him for fraud. I don't know, there's several things on there. Mismanagement of government documents. He really messed up when he did that.
And where's he at right now? What city?
Well, that one's either his main office is in Atlanta, but they have an office in San Diego. He's in trouble for that one because I got a criminal complaint.
Okay, you sound pretty knowledgeable in all this, but
You
I
have
guess
to be. You have to
yeah.
learn the law.
I know. I don't know if I could have done this, but let's continue with the story here, and then we'll get to a couple more questions.
I went and talked to him. We rock along here, and then March the 20th, I get a letter back from the appeals court that they have dismissed my case for want of jurisdiction. Which to me, that means, based on what I've studied, they don't have jurisdiction. But yet in that want, then they had dismissed my writ of mandamus for want of jurisdiction. And the appeals court is the one that has to sign the writ of mandamus. So how can they not have jurisdiction over it? Also, when they dismissed my appeal, they put on there that I'm responsible for the opposing party's attorney fees.
Is that legal or?
Yeah, according to them. No, I ain't paying them. I don't know. They never give me a bill. Don't want to give me a bill. Now, they did send a letter out. We got Monday where they're wanting a trial this month. So that's probably what it's over. That is not going to matter because I'm fixing to file a new lawsuit on the illegal foreclosure, the fraud, the forgery, everything in it. I've got every one of the bankers and attorneys, anybody that had anything to do with this is listed in this lawsuit. Then I am filing another criminal complaint against the JP and the judge for judicial misconduct, oppression. And then they're getting a federal civil rights lawsuit. So the law is simple. The law is black and white. So when you get attorneys and judges involved, that's where it all goes to, well, I'll be nice. It goes downstream.
Well, that's what I'm saying. People, if we abided by the Constitution, right?
Well, it's just like you and I. If we break the law, we pay the consequences.
True.
If a judge breaks the law, he has nobody to hold him accountable.
Yeah, he think he is a law.
He has nobody to hold him accountable. In the state of Texas, the Commission on Judicial Conduct, example, right now it has 11 members, 4 judges, 2 attorneys, and 5 common people. So who has a majority on that council or commission? You got 4 judges and 2 attorneys and 5 common people. Now there's a law down there now trying to be passed, and it's made it through the Senate. Now it's in the House to where they're going to change that to where you still have 4 judges and 2 attorneys, but then you're going to have 7 common people. But don't know who's going to appoint them. That's the other problem.
So where are you at now? You're going to file the lawsuit.
Oh yeah, I'm filing lawsuits and criminal complaints.
And what do you think is going to be the end result of everything? Do you think you're going to get your house back? Or, I mean, you're in your house, but what do you think is going to happen, the end result?
I don't know. I know what I'm asking for. What we've had to spend out of pocket to survive. I'm asking for so much for every day we didn't have our home. I'm asking for damages for medical and therapies that we couldn't give her because our credit got ruined and we didn't have the money to do it because we were trying to survive. And I want a trial by jury. When you get a court where the judge rules from the bench, he's no longer a judge. He became an attorney. A judge is supposed to be biased, unbiased, and he's just a referee in a court case. When you get an administrative court and you get a judge ruling from the bench, he's strictly an administrator of the court. He is not a judge. The only people in the country, in this whole United States and the way our system was set up, that can give you a true ruling is a jury.
That's a very good point. And when you mean ruling by the bench, what does that mean?
When a judge makes a ruling sitting on a bench, you don't have a jury. You get a bench ruling. And that's an administrative process. The administrative process was invented for corruption. You know, and supposed to in your cases and everything that you do, like your motions, if you have case law, and case law is another case that's already been presented and already been ruled on. And if you present case law that pertains to your case that was ruled in a certain way, they're supposed to follow that as considered common law. They didn't even address 13 pages of case law I sent with my writ of mandamus. 13 pages that pertain to our case, or my writ of mandamus. They just, we don't have no jurisdiction.
How do you know they didn't review it?
They didn't review it. If they'd reviewed it, they'd have looked at it. They would have known I was right.
So what do you think's happening here? What's in this whole situation? What do you think's happening?
Well, the people I have met and gotten acquainted with that are dealing with cases, and my case is bad, but let me tell you something. Mine ain't nothing to family law. Them boys, that is the corruptest system you ever seen in your life. Just from the guys that I met that are dealing with it. I'll give you an example. I helped a guy with some stuff to research and do some stuff. The judge sent down the court order on his custody. She's the one that set it down, what his custody rights were. He went to pick up his kids from his ex's house after she told him on a text that he could come get them. Picked them up. She filed harassment charges on him and trespassing. And in court, it was his day to have his child. And the judge can't even break her own order. She's the one that gave the order. That's his day, his time with his child. The judge kept him from seeing his child and gave a protective order against him. And he had the proof that he could pick them up. I'm telling you, you get into that one, and I can get you with some guys that get you into that one. It'll just blow your mind.
Yes, to be honest, it's like the more you dig.
Oh, it gets deep, man. I know a guy right over here that they picked him up for theft of services. Okay? Same judge, held him in jail for 3 days. Didn't arraign him for 3 days. Didn't even give him his constitutional rights. Didn't even hear his case. Now he's got charges filed against him for theft. Should have been dismissed because the guy gave him money. Every time they would go over there for 2 months, he never was there where to let him into work. So and I don't blame him, driving back and forth to Odessa X number of times costs money. But they've got theft charges on him because he didn't complete the work. Even though he went over there like 14 times and never got in to complete the work.
So winding down here, what would you tell people that watch this video? Because you're talking a lot of legal jargon that I'm sure a lot of people, because I've seen the Facebook group that your wife showed me. What would your final message for everybody watching here? What would you tell the viewer that watches this whole video to the end?
Read the law, learn your rights, and know going in, if you're pro se and defending yourself, they're gonna try to run over you. You have avenues, but you got to find them because nobody's going to tell you about them.
Why don't you get a lawyer?
I tried. I called 75. Nobody takes the case because they have to go against the court. But I'll tell you something. Anybody that's having to get into this, use AI, but double check what it tells you. Because I can promise you in 3 or 4 years, there's actually a bill now in the legislature against pro se attorneys, where they have to be approved by the court before they can even represent themselves. And the ones that are bringing that is a group of lawyers, because AI is taking over what attorneys do.
We love AI.
Oh, I mean, you can write your own contracts, you can write your own motions, you can write your own lawsuits, any lawsuit, to federal, to whatever. Just, if you use it, double check what it tells you.
Totally agree. Final words, go ahead.
Final words, it's all in God's hands. We've trusted him from the beginning. And I feel like if we weren't doing what his will was, we still wouldn't be in this house. And that's the main thing. Whoever this is happening to or in this situation, turn to him because he'll get you through it.
Now, we were going to drop the video a couple days back. I was waiting for the okay from Michael and his family. He got a hold of me and said, Nino, pump the brakes. We have some breaking news update about the story. So, Michael, why did you tell me to hold on with the story before we publish the actual story of your situation?
I wanted to file my lawsuit and my motions to vacate. Filed my lawsuit last Friday and filed in district court to set aside the illegal foreclosure, fraud upon the court, fraud on us. So that's been filed in district court. Also, I did a lot more research, and if you're going to do this pro se, it's going to take a lot of time. Just get ready.
Okay, so what update do you have for us after everybody done watched the video? What's going on?
I filed a motion to vacate the void judgment. I filed order to sign the motion for a void judgment. I filed a motion for lack of jurisdiction because the moment in testimony in my transcript on page 14, and I believe it's lines 13 and 14, the judge was informed that there was a cloud on the title, a title dispute. Then again on page 29, he was informed again there was a dispute on the title, and we had filed a trespass to try title case on the house, on the property. With those two right there, the case by Constitution is to be shut down, dismissed for lack of jurisdiction, or moved to district court. And I may have said this previously, I don't know, but before we went to JP court on the eviction, we filed our counter criminal and civil complaint, our trespass try title, affidavit title possession, which is the way we're supposed to do it according to the rules that you find in the property codes and the courts. All right. All that was filed with the JP court, the county court, and the district court. Okay. Anytime in county court at law, if a title dispute is brought, it's immediately, and JP court, they're immediately shut down the case and move it to district court. By him going ahead and ruling on my case with lack of jurisdiction, that becomes a void case and a void judgment.
By the law.
By the law. Void ab initio. It's a nullity. None of it exists. The judge continued to rule on my case, made me post a $4,000 bond in county court, and this is after I'd already posted a $1,000 bond in JP court on a void judgment. So I posted a $4,000 bond in county court to appeal my case, which there's no appeal on a void judgment. There's no appeal. It's void. Ab initio, no, nothing there. By them making us pay a $4,000 bond, it's unconstitutional and illegal. It's another due process of our property. Now, I filed those two motions on Friday, the motion to vacate and the lack of jurisdiction. Over the weekend, I did more research. And this is my opinion, not fact. I tried to give the court two outs. The first one, motion to dismiss for lack of jurisdiction. The second one, a motion to quash the writ of possession that he issued on a void judgment. Because by law, any order, writ that he proceeds to issue is null and void because it's all issued on a void judgment. But when the sheriff tells you, if the judge sends down an order, he has to follow it. And after filing the motion to quash and the motion to dismiss with an order to sign the motions, with a notice of a hearing and a certificate of service to the opposing counsels, I waited. Then yesterday,
Which was what day?
that was Monday, I filed those.
Yesterday, no, I filed the motion for, man, my days run together and I've been up, I haven't slept like 2 hours doing all this stuff, trying to figure this out. Yesterday, I filed the motion to dismiss and the motion to quash the writ of possession. And I thought, well, this is good because generally when I file something, within 30 minutes, it's back in the clerk's office, court reviewed on the bottom of it. Well, he hadn't sent anything back down, so I thought, when I went yesterday, no, he didn't send anything back down. So I filed those 2 motions. And I thought, well, maybe we're getting somewhere. Well, then the clerk calls me today and tells me he sent the folder back down. He didn't sign anything. He just wrote court reviewed on it, no trial set. The court rules say on a motion to vacate, motion for lack of jurisdiction, motion to quash for jurisdiction, and the writ of possession, they don't need a trial. That can be done with a judge's signature. So I have 2 more motions I'm going to file in the morning, and I feel like they're fixing to come at me and say I'm a vexatious litigant where I can't file anything else.
They can do that?
Well, they can do it, but I don't know if it'll ever hold up because I'm not. I followed the law with everything I've done to the best of my ability. So I have 2 more motions I'm going to file in the morning, and these are going to get in depth because upon research, when I filed my notice of appeal that I had to file at 56 days, not my 90 days. When I filed my notice of appeal to the 11th Court of Appeals, they are supposed to go through everything in the case file, transcript. When they read the transcript, they are supposed to, let me phrase this correctly. I asked ChatGTP and then I researched this. When they sent all my stuff to the 11th Court of Appeals, did they have a duty to act when they found out that county court at law had no jurisdiction because of lack of jurisdiction? It's a void judgment. And this is what I've discovered. Yes, the 11th Court of Appeals had a duty to act if the appellate record clearly showed that the county court at law lacked subject matter jurisdiction, especially over title disputes, which is exclusively within the jurisdiction of district courts in Texas. Here's the key legal principles. Appellate courts must review jurisdiction on their own, even if it's not raised by the parties. Lack of jurisdiction is a fundamental defect, and any judgment issued without jurisdiction is void, not merely voidable, void. What they should have done, reviewed the transcript. If the record, for example, pages 14 and 29, showed the issues of title were raised in the county court proceeded anyway, the appeals court was required to declare the judgment void for lack of subject matter jurisdiction, dismiss the case, or remand it to the proper court, district court, if appropriate. Address subject matter jurisdiction first before reaching any other issue on appeal. And it lists the case law, Texas Association of Business versus Texas Air Control, Maplewood Investment versus Lyles, Patterson First National Bank. If the 11th Court of Appeals ignores the jurisdictional issue, even though it's evidence in the record, you may be able to file a motion to recall the mandate or a motion for rehearing en banc. Raise the issue in a petition for review to the Texas Supreme Court. Or you can pursue federal relief under due process claims if harm resulted. Now there's another part to this through the appellate's court. And I need to find that because I don't want to misquote this. And I also learned today is when we did go to court after they did not serve us a court date, and it was brought up in my testimony that we were not served a court date, that the other county court at law judge vacated the judgment because we come in because we'd received an email that they ruled for the plaintiff because we failed to appear. Well, the other county judge vacated that judgment. And the court clerk told me again, we will set you a new court date and notify you. Never did. The only thing we got was a letter from the opposing counsel, which is not legal notice of the court. Okay. When the appeals court dismissed my case, our case, they dismissed with want of jurisdiction, which says they didn't have jurisdiction on the case, right? But then they taxed me, Christine and I, for the fees, the court fees, everything to do with my case. Well, here's what you find out when you do some research.
Uh-oh.
That describes multiple serious legal and constitutional concerns. Absolutely, you can and should address it in both your trial court filings and potentially in federal court. Appellate court dismissed for want of jurisdiction, but issued sanctions and fee orders on us. That is legally contradictory and constitutionally improper. If the appellate court lacked jurisdiction to hear the case, and then it had no authority to issue any orders, including fees and assessments, any action beyond dismissal for lack of jurisdiction is void. The issue you run into when you file motions, especially on a void judgment, and this is my personal opinion, don't get me wrong. If you bring up a void judgment and you ask them to vacate a void judgment, and now keep in mind, this is my personal opinion.
Go ahead.
It's hard to get them to sign or to vacate a void judgment. And the reason why, if the court was wrong in one case, now that brings up the fruit of the poisonous tree.
Mm.
And I think you know where that goes. That's deep. Thus, the motions for dismiss, the motion for lack of jurisdiction. To me, I gave the court a chance to save face.
And what do they do?
Court review, no hearing set.
When they should have did what?
Do what?
When they should have done what?
They should have just signed the motion. Gave them an opportunity to get out of it without losing any, or to save face, any other way to put it.
So where do you go from here?
File 2 more motions tomorrow and we'll have an update on how that plays out. The ones tomorrow are constitutional. I don't want to get into that yet till I get them filed. But according to what I've researched and what I'm doing, it's big.
I don't know if we want to touch on, but you thought it was very important to give this update. Why is that?
I want everybody to know that Christine and I are of sound mind. Because I have a friend from Lubbock, and he's probably going to be on this podcast for long. And he was in a divorce. His decree was void because the judge has been his wife, because she's still his wife. They're not divorced because it's a void divorce decree. He was attorney and judge on the same case. That's a constitutional violation and an automatic disqualification. They have thrown him in jail for child support that he doesn't owe 3 times. They've taken his property because the city of Lubbock wants to make a river walk. And he'll be here to tell his story. He's already told me. But the retaliation is the reason I want everybody to know if something happens. Christine and I have special needs daughters. We have made sure they are taken care of. The only thing they have ever wanted for is the therapies and procedures that we haven't been able to afford when all this illegal foreclosure and fraud first happened. And 10 years, we've dealt with this 10 years and still dealing with it. But filing this lawsuit, hopefully, will get us on the right track to put it all behind us. And I'm just saying again, if you're representing yourself, or even if you use an attorney, you double check what he tells you. And if you do it yourself, be ready for long hours, little sleep, and a continuous battle. Because in my personal opinion, they run over pro se defendants because they don't think we know what we're doing. And I'll be honest, I came from work today. I should be retired by now, but I'm not. And won't be able to for a while. And it's not right. It's not right what they've done to my children. They stole their childhood. And people can say what they want to about the foreclosure. I have documentation and proof. I could have paid the house off and the bank refused my money. Told me on the phone in front of a JP, we don't want your money, we want your house.
I would say just let this be a lesson to everybody to take heed. I thought about it just recently. They can just call your note and someone else has got a hold of me that they're trying to take their property in I would say a somewhat similar fashion. And I think it's pretty deep. I'm going to hold my comments on this video. But final words that you want to tell the people out there. Go ahead, Michael.
Stand your ground, because they will run over you if you let them. I mean, don't let them steal your property. When it comes to your mortgages, there's a lot of information that is not shared that is truthful. That is truthful. There's a lot of people on TikTok, one lady in particular, and I've researched this enough to know that she's done her research. And it's just, this whole system, our whole judicial system has been built around money. It's all about money. I can't prove it, and I won't say anything until I research this. But if I can find this out, definitely share it with people so they can all do their research and find out how corrupt mortgages are.
All right, Michael, well, I appreciate your continuing update here, and I wish you the best of luck.
Well, I'll have you another one after tomorrow when we find out what happens tomorrow.
Can't wait. All right, God bless.